Hey there, freaks and sickos. Welcome to my campaign. By the time this video is up, we will have entered into the next presidential administration in the United States, or perhaps a better way of putting it is we'll be entering a presidential administration that never was. And the reason I say that is because of what is objectively the worst branch of government, the judicial branch, and the top guy in that role, Justice John Roberts, wrote about that. What I have here is the 2024 year-end report on the federal judiciary. He wrote this, and it's something that the Supreme Court usually does, and the people just shrug it off. It's just another formal document made by the highest court of the land. But this one is quite different in tone. Or so I have heard, but I'm not gonna just go off by what someone else said when they they knew a guy that knew a guy, they knew another guy who therefore then knew another guy that heard about this. No, I'm gonna read the whole thing in its entirety, and then, as John Roberts' boss, as a person, as a member of the Society of We the People, a citizen of the United States, which is clearly defined in your employee manual I have behind me back there. I don't know if you can see it very well, but there it is. Yes, I do, in fact, have a copy of the Constitution of the United States behind me. Look over there and feel free to edit this very clip for meme purposes. So, for the sake of integrity, I am going to read this report in full, just like I did the 2024 year-end report on the federal judiciary. This is exactly what it says. In December 1761, a little more than 1 year into what would be a 59-year reign, King George III decreed that from the date forward, colonial judges were to serve at the pleasure of the crown. This royal edict departed from the long-standing practice in England, enshrined by Parliament in the 1701 Act of Settlement of allowing judges to retain their offices during good behavior. The king's order was not well received. To the colonists, stripping lifetime appointments from judicial officers marked yet another instance in which the British subjects living on the west side of the Atlantic Ocean were treated as second class. George III compounded the insult about a decade later in 1772 when he established a salary set by the Crown for Superior Court judges in Massachusetts, preventing them from accepting the then prevailing local government wages for their services. A prominent Boston lawyer by the name of John Adams protested the king's actions by making colonial judges entirely dependent on the crown for bread as well as office. Despite widespread disapproval in the colonies over this interference with the independence of their judges, the king held his ground. Accordingly, the ninth of 27 grievances enumerated by the Declaration of Independence charged that George III has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. After securing independence, the fledgling United States did not immediately set about creating a national judiciary. Also, yes, I do have this document up on both of my monitors. Anyway, continuing, after securing independence, the fledgling United States did not immediately set about creating a national judiciary. That bears repeating. Continuing, indeed, among the many defects of the Articles of Confederation, the absence of any mention of a judicial branch, or judges at all, seems particularly glaring. The Constitutional Convention of 1787 remedied that oversight. In a tidy rebuttal to the King, Article 3, Section 1 of the Constitution of the United States states that the judges, both of the supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. You might have expected the man who soon would become the first Chief Justice of the United States, John Jay, to have authored the portions of the Federalist Papers devoted to the judicial branch. But, as I explained in my 2019 year-end report, Jay spent the winter of 1788 recovering from a severe head injury sustained while trying to protect a group of medical students from an angry mob who thought, erroneously, that the students were stealing cadavers from graves to practice surgery. As Jay rested to heal the two large holes in his forehead, the task of championing judicial independence fell to Alexander Hamilton. Quoting the French politician philosopher Montesquieu, Hamilton endorsed in Federalist Number 78 the principle that there is no liberty if the power of judging be not separated from the legislative and executive powers. Hamilton anticipated that the relatively weak judicial branch, possessing neither the sword nor the purse, would require all possible care to defend itself against the attacks of the other branches. To that end, premature tenure of judicial offices would free judges to perform their essential role as the bulwarks of a limited constitution against legislative encroachments. In Federalist Number 79, Hamilton argued for judicial compensation that could not be diminished, noting that the power over a man's subsistence amounts to the power over his will. Hamilton's masterful defense of judicial independence also went on to presage Chief Justice Marshall's foundational decision in Marbury v. Madison, recognizing the duty of the courts to declare all acts contrary to the manifest tenor of the Constitution void. The independent federal judiciary, established in Article 3 and preserved for the past 235 years, remains, in the words of my predecessor, one of the crown jewels of our system of government. Indeed, there is no exaggeration to include, as Chief Justice Rehnquist did, that the creation of an independent constitutional court with the authority to declare unconstitutional laws passed by state or federal legislatures is probably the most significant contribution the United States has made to the art of government. Before the American founding, no other country had found a way to ensure that the people and their government respect the law. One reason judicial review has endured and served us well lies in yet another insight from Chief Justice Rehnquist, articulated in his 2004 year-end report. The Constitution protects judicial independence not to benefit judges, but to promote the rule of law. Or, as Justice Kennedy put it, judicial independence is not conferred so judges can do as they please. Judicial independence is conferred so judges can do as they must. In the same 2004 report, which would prove to be his last, Chief Justice Rehnquist observed that criticism of judges has dramatically increased in recent years, exacerbating in some respects the strained relationship between the Congress and the federal judiciary. That statement is just as true, if not more so, today. In truth, some tension between the branches of government is inevitable, and criticism of judicial interpretations of the people's laws is as old as the Republic itself. Wow, you are just weaving your way in and out of self-awareness as you see fit. Don't you, little buddy? Anyway, continuing. In Hamilton's and Jefferson's time, the debate was framed by pitting those who believed that the government's powers extended only to those specifically enumerated in the document against those who found in it more expansive powers. Today, we often use terms like originalism and pragmatism to describe these differences of opinion. The political branches sometimes inquire into the judicial philosophy when considering nominees for the federal courts, but the oath and the duties that follow are the same regardless of the president who nominated and the Senate that confirmed every new Article 3 judge. Judicial review makes tensions between the branches unavoidable. Judicial officers resolve critical matters involving life, liberty, and property. At times, as Hamilton recognized, an independent judiciary must uphold the Constitution against the shifting tides of public opinion, as no man can be sure that he may not tomorrow be the victim of a spirit of injustice by which he may be a gainer today. It should be no surprise that the judicial rulings can provoke strong and passionate reactions, and those expressions of public sentiment, whether criticism or praise, are not threats to judicial independence. To the contrary, public engagement to the work of the courts results in a better informed polity and a more robust democracy. Indeed, when working in panels, judges themselves join from time to time the ranks of critics through concurring and dissenting opinions. Two district judges, independently looking at the same legal issue, can also come to different conclusions, leaving it to the higher courts to resolve the split of authority. And room for disagreement is almost endless when it comes to the vast swath of trial court work that involves the application of variable legal tests to unique fact patterns in individual cases. In last year's year-end report, I opined that the application of discretion in these situations explains why machines will never fully replace human judges, but it also creates fertile ground for debate and criticism. At the end of the day, judges perform a critical function in our democracy. Since the beginning of the Republic, the rulings of judges have shaped the nation's development and checked the excesses of the other branches. Of course, the courts are no more infallible than any other branch. In hindsight, some judicial decisions were wrong, sometimes egregiously wrong, and it was right of critics to say so. In a democracy, especially in one like ours with robust First Amendment protections, criticism comes with the territory. It can be healthy, as Chief Justice Rehnquist wrote, a natural consequence of life tenure should be the ability to benefit from informed criticisms from legislatures, the bar, academy, and the public. Unfortunately, not all actors engage in informed criticism or anything remotely resembling it. I feel compelled to address four areas of illegitimate activity that, in my view, do threaten the independence of judges on which the rule of law depends. One, violence. Two, intimidation. Three, disinformation. And four, threats to defy lawfully entered judgments. So after 3 full pages of fluff, this is where the document quickly goes downhill fast. Faster than the Double Diamond Wall Ski Trail in Ellicottville, New York. In fact, just from the order of these 4 points, I am already picking up the vibe that from here, the rest of this document is going to be even more crazy the more I read it, and then just have a tiny bit of fluff at the end to justify itself. Nothing tested, nothing believed, though. Continuing. There is, of course, no place for violence directed at judges for doing their job. Yet, in recent years, there has been a significant uptick in identified threats at all levels of the judiciary. According to the United States Marshal Service statistics, the volume of hostile threats and communications directed at judges has more than tripled over the past decade. In the past 5 years alone, the marshals report that they have investigated more than 1,000 serious threats against federal judges. In several instances, these threats have required the assignment of full-time U.S. Marshals Service security details for federal judges, and approximately 50 individuals have been criminally charged. In extreme cases, judicial officers have been issued bulletproof vests for public events. Fortunately for our nation's judges, the vigilance of law enforcement officers and investigators has stopped many threats of violence before they could be carried out. Indeed, from the founding of our republic in 1789 until 1979, only one federal judicial officer, Chief Justice John Slough of the New Mexico Territorial Supreme Court, was killed in office. And the quarrel that led to Slough's shooting in the billiard room of a Santa Fe hotel in December 1867 did not stem from a judicial ruling, but rather from the judge's off-the-bench criticism of a territorial legislator. In more recent decades, however, disgruntled litigants have perpetuated acts of violence against several judges and members of their families. Between 1979 and 1989, 3 federal judicial officers, 2 district judges, and a circuit judge were killed for doing their jobs. In 2005 and 2020, close relatives of federal judges were shot to death by assailants intent on harming the judges who had handled their cases. More recently, in 2022 and 2023, state judges in Wisconsin and Maryland were murdered, and also at their homes. Each instance constituted a targeted attack following an adverse ruling issued by the judge exercising ordinary judicial duties. And while I do not condone violence like Chief Justice John Roberts and his illegitimate court, I would also like to point out that there is a lot of room for interpretation in that last sentence, especially in the case of Chief Justice John Roberts. These tragic events highlight the vulnerability of judges who sign their names to the decisions they render each day and return home each night to communities where they remain involved as neighbors, volunteers, and concerned citizens. Judges cannot hide, nor should they. I am grateful to the many federal and state legislators who have stepped forward to sponsor bills shielding judges' personal identifying information from the public domain. That's the tone I'm getting in my head. Sorry, I'm trying to be objective here, but it's hard to take your personal bias out of things. Not impossible, though. I did catch myself there, but for the rest of this, I'm going to be reading in a normal tone of voice. I do apologize for that misguided decision. I also thank Congress for providing additional security funding to protect the physical security of judges and justices. As I commend the marshals and other officers who work on the front lines day and night to keep judicial officers across the country as safe as possible. It is regrettable that law enforcement officers must now dedicate significant additional resources to protecting judges, tracking and investigating threats against them, and prosecuting those who cross the line between lawful criticism and unlawful threats or actions. Of course, attempts to intimidate need not physically harm judges to threaten judicial independence. In earlier times, these provocations usually were directed at judges' homes. Perhaps the most egregious example involved U.S. District Judge Julius Waits Waring. As a judge in South Carolina from 1942 to 1952, Judge Waring issued numerous rulings opening voting and educational opportunities for Black Americans. Local residents, outraged by these decisions, burned a cross in the judge's lawn, fired gunshots at his home, and hurled a large lump of concrete through his front window. Elected officials called for his impeachment, but Judge Waring stood strong until taking senior status at age 71, secure in the knowledge that an equal protection challenge to racial segregation had made its way to the Supreme Court. By the time the landmark decision in Brown was issued in May 1954, Waring had moved to New York City, returning to South Carolina only in 1968 to be buried in Charleston near the federal courthouse that now bears his name. Today, in the computer era, interesting choice of words, intimidation can take different forms. Disappointed litigants rage at judicial decisions on the internet, urging readers to send a message to the judge. I sent a peaceful message to the Supreme Court. I'll get to that part in a moment. They falsely claimed that the judges had it in for them because of the judge's race, gender, or ethnicity, or the political party of the president who appointed the judge. For example, setting fire to or blowing up the courthouse where the target works. Occasionally, court critics deploy doxing, the practice of releasing otherwise private information such as addresses and phone numbers, which can lead to a flood of angry, profane phone calls to the judge's office or home. Doxing also can prompt visits to the judge's home, whether by a group of protesters or worse, an unstable individual carrying a cache of weapons. Both types of activity have occurred in recent years in the vicinity of the nation's capital. Activist groups intent on harassing judges have gone so far as to offer financial incentives for posting the location of certain judicial officers. Oh, yeah, we in the good part now, boy. Public officials, too, regrettably have engaged in recent attempts to intimidate judges, for example, suggesting political bias in the judge's adverse rulings without a credible basis for such allegations. So now we're at the part of the document where Justice Roberts, allegedly, as in allegedly he is a judge, went from weaving in and out of self-awareness to try and get my pity, his boss's pity, to going full speed in a private jet away from himself, away from the reality of the situation and his place in it. Continuing, within the past year, we also have seen the need for state and federal bar associations to come to the defense of a federal district judge whose decisions in a high-profile case prompted an elected official to call for her impeachment. Attempts to intimidate judges for their rulings in cases are inappropriate and should be vigorously opposed. Public officials certainly have a right to criticize the work of the judiciary, but they should be mindful that their intemperance in their statements when it comes to judges may prompt dangerous reactions by others. Disinformation, even if disconnected from any direct attempt to intimidate, also threatens judicial independence. This can take several forms. At its most basic level, distortion of the factual or legal basis for a ruling can undermine confidence in the court system. Our branch is peculiarly ill-suited to combat this problem, because judges typically speak only through their decisions. We do not call press conferences or generally issue rebuttals. To make matters worse, as I noted in my 2019 year-end report, the modern disinformation problem is magnified by social media, which provides a ready channel to instantly spread rumor and false information. At that time, I endorsed a renewed emphasis on civic education as the best antidote for combating the epidemic of misinformation. I am happy to report that the bench, bar, and academy have embraced this essential project, writing and speaking about the distinct role in courts in American government and explaining what they do and don't do. But much more is needed, and on a coordinated national scale. I know where I live better than he does, and that is not going to happen. Not only to counter traditional disinformation, our political system and economic strength depend on the rule of law. Wow, a true statement! Finally! After paragraphs of projection. Anyway, continuing, the rule of law depends, in turn, on Article 3 of the Constitution and judges and justices appointed and confirmed under it. 2! Way to go! Continuing, those men and women remain connected to the people they serve and do their work in the public eye. 3! Chief Justice Taft is the only person to have served as head of the judicial and a political branch. Nice while it lasted. Continuing. As he put it, nothing nothing tends more to render judges careful in their decisions, as anxiously solicitous to do exact justice than the consciousness that every act of theirs is to be subject to the intelligent scrutiny of their fellow man and their candid criticism. But violence, intimidation, and defiance directed at judges because of their work undermine our republic and are wholly unacceptable. The federal courts must do their part to preserve the public's confidence in our institutions. We judges must stay in our assigned areas of responsibility and do our level best to handle those responsibilities fairly. We do so by confining ourselves to live cases or controversies and maintaining a healthy respect for the work of elected officials on behalf of the people they represent. I am confident that the judges in Article 3 and the corresponding officials in other branches will faithfully discharge their duties with an eye toward achieving the successful cooperation essential in our nation's continued success. As always, I am privileged and honored to thank all the judges, court staff, and other judicial branch personnel throughout the nation, for their commitment to upholding judicial independence and the rule of law through their outstanding public service. Best wishes to all in the new year. John G. Roberts, Jr., Chief Justice of the United States, December 31st, 2024. Let me just grab a document here real quick that might explain my frustration with John Roberts and his Supreme Court, allegedly, and his attitude as a judge. So, you all have proof that I read the whole thing, and if you skip to this part of the video, I don't blame you, but I would recommend coming back to it because this document here, this end of the year report by the Supreme Court of the United States, is very much a doozy. That is a hilarious read in just how much contempt the Supreme Court of the United States has for its boss, we the people, outlined in its employee manual, the Constitution of the United States, which I have also read in full on this very YouTube channel. For someone who is supposed to be enforcing this thing, it wasn't mentioned very much. He mentioned the very brief and malleable Article 3, which says nothing about independence or a guarantee of independence. In fact, the branches of government are supposed to communicate with one another, and that's perfectly fine and reasonable. We don't just have one branch of government we have three, and they're not just separate, they're meant to be co-equal, as in they have equal amounts of power shared between them. And that if there is an imbalance, one is supposed to correct the other. There is a system of checks and balances, and it is crystal clear that Justice Roberts very much opposes having any of that placed on him. To the Supreme Kangaroo Court of the United States, I must point out that your power doesn't come from your independence. It comes from we the people. It comes from us and the other two branches of government. In fact, the very structure and manner and boundaries of your authority are defined in a number of different laws that pass. The fact that there are 9 judges instead of 7 is because of a federal law that added 2 seats to the bench. Any serious reading of the Constitution makes it clear that anyone has the right to call for your impeachment at any time, and that anyone has every right to question all of your authority at any time. And it doesn't have to be a truthful statement either. An appointed judge is no more special in this than a member of Congress or the president himself. And if the government does become so evil, so corrupt, and so contemptuous of the Constitution itself, all of the Founding Fathers made it clear in the Federalist Papers, not just the ones that you cherry-picked, but in their entirety had the sentiment that, yeah, if things are bad enough, if they're corrupt enough, if the government is tyrannical enough, the system is bad, it must be overthrown, we should probably make a new one, or use the system of checks and balances in the Constitution to remedy the situation. And that has to be done now. It has been made clear as air, the very air that is used to make the guarantee of free speech, that judges are becoming less independent and more partisan, that they are spending more time on vacation and with their bribers than concerning themselves with the Constitution or the people, and often showing open contempt. You have Sam Alito believing as the voice of God that he has the absolute authority to make any decision he wishes on things like bodily autonomy and what adults are allowed to view privately, and whether that should be private at all, or if Texas should have the authority to go and make a list for the town crier of who has been looking at naughty bits on the internet, which is a part of the Free Speech Coalition case pending before the Supreme Court that our corrupt SCOTUS clearly does not want to discuss, because in Alito's head, he has made a decision before anyone has said anything. That's what a kangaroo court is. That's what the Supreme Court has become. Making decisions of guilt or innocence, constitutional or not, on personal whims and not objective facts. Objective words in this paper. In fact, that one of the most infuriating things that I read in this statement is the idea that the Constitution has an absolute limit on the powers granted to governance, and that is not true. It doesn't. If the laws involved are meant to expand the fundamental rights of the people from tyranny in all regards, in the Ninth Amendment, that whole part said that whole amendment, that right there says unenumerated. So yeah, what the Ninth Amendment says doesn't limit judges to saying the government has the right to do everything, but it does give some discretion on whether or not this thing should be a right or not, and if the government is granting more freedom to the people or not. The Federalist Papers also make it abundantly clear that there is, in fact, a separation of church and state, but when a majority of the Supreme Court goes, nah, not for my religion, I think there should be special exemptions of bigotry granted in places where I feel like it. You're not speaking on behalf of the Founding Fathers, you are talking out of your ass. In fact, when the Dobbs decision came down, they had to pass, finally, the Respect for Marriage Act to take some independence away from you out of the fear that you guys, after not even 20 years, are gonna give gay marriage and then strip it away because of personal grievances against groups that you don't like and ignoring the 14th Amendment. I don't even know if this Supreme Court has enough integrity to stand up for the entirety of the 14th Amendment and say to the Trump administration that people are granted citizenship at birth when it clearly does say that. But perhaps, well, absolutely, the biggest slap in the face to the Founding Fathers, to the Constitution, and to America itself is to rule in favor of Trump in Trump v. United States against the United States, which grants your power from the Constitution. To say, you know what, the president just has absolute immunity against all laws because we said so, and we're going to ignore the people's right to not have to deal with a tyrannical president. Like, we're just going to ignore the whole Enlightenment, the whole revolution, all of it, because we're weak, feeble men who need to gather around the weak, feeble president and give him exactly what he wants. We're afraid of the wrath that would come from his supporters, but not the far greater wrath of everyone else. If you go back in history, you'll know that in decisions like the one that made separate but equal, and also the Dred Scott decision, that judges are not just as fallible as the other two branches of government, but even more so, and don't exactly deserve automatic respect for the virtue of being a judge. And that they'll make decisions that are completely incorrect and ripe for being ignored. That reforms to the Supreme Court need to come from somewhere, when they are openly contemptuous of their job, their boss, the people, all of it, to pursue partisan aims at the behest of days, if not weeks, of brabbing timing in the form of gifts and vacations that were not earned, not part of their compensation, and just the reason that this Supreme Court has the lowest approval rating ever of all time. Worse than it was during the Civil Rights Movement or before the Civil War. The reason the people don't like you is because we feel like you believe that some people are more equal than others, and that you're not really enforcing the Constitution so much as making excuses to dodge it. For Republican officials to dodge it, for Republican states to dodge it, for Republican businesses to dodge it. Enough is enough is enough. And if action isn't going to come from the federal government, then the authority not granted to the federal government belongs to the states. I believe that states like California and Illinois need to put conditions for judicial review of state laws. And whether you assholes get any respect whatsoever, or if you could just be debenched for this one, we'll interpret the Constitution for you, and because we're doing a better job than you, because it is your job to uphold the Constitution, even and especially when you don't like it and hear such harsh words on the internet in the computer era. I believe that states like California, Illinois, and in 3 years, Minnesota should demand proof of your integrity before cooperating with you in any meaningful way, before giving you evidence, before letting state judges even so much as talk to you. If we're brave enough, if Gavin Newsom is brave enough, if J.B. Pritzker is brave enough, and mean it when they say they will protect their people from the tyranny of Trump and all the weapons he will use for that tyranny, well, we got to take away one weapon. We got to take away his bribed and corrupt Supreme Court. We need to take away the bribes too. So here's something very reasonable, something that any judge acting in good behavior would have no qualms against. I believe that all judges, as a condition of doing judicial review, need to show their papers. They need to give the public and the press, which there's a freedom of the press in here, and I do believe the press has a right to know when they ask, and if they're not going to get it by statute, every communication, including the system logs, every text, every email, making sure none of that is tampered with. And if there is a reasonable doubt on the information given, yeah, a state court should be allowed to say, nope, we're not going to listen to you. We're not going to listen to you because you're compromised. Because you're no longer independent. Because you listen to your bribers. Your lavish billionaire bribing Timon, and not anything in front of your face, not the case in front of you, Not we the people, just Harlan Crow. If you're not gonna follow your oath, then it is the duty of everyone else with any amount of power to do that for you. Every swipe of your credit card, too, every transaction, you need to provide proof that you have integrity, or a state judge should have a right to debench you for a case. Not listen to your opinion. We need accountability in the judicial branch so that it can, once again, be co-equal. And if I'm elected to the state senate in Minnesota, that's exactly what I am going to push the hardest for. We can't have judges pretending to be kings anymore. We just cannot. The lowest, most rotten behavior